Hi, and welcome to our discussion of AI Inventors and the Law, presented by the UCLA Institute for Technology, Law, and Policy, a new interdisciplinary research center whose mission is to foster research and analysis to ensure that new technologies are developed, implemented, and regulated in ways that are socially beneficial, equitable, and accountable. My name is Michael Karen-Nicholas, and I'm the executive director of the ITLP. I will also be the moderator for today's conversation, which will consist of about 45 minutes to an hour of conversation among the panelists, followed by an audience Q&A. So I would invite all of you to enter questions into the chat as we go, and we will get to them at the end. I'll begin by acknowledging on behalf of the Institute for Technology, Law, and Policy our presence on traditional, ancestral, and unceded territory of the Gabrielino Tongva peoples. We have a fantastic pair of guests with us today. Alex Moss is the executive director of the Public Interest Patent Law Institute, a nonprofit dedicated to ensuring the patent system promotes technological innovation and access for the public's benefit. Prior to that, she was the Mark Cuban Chair to eliminate stupid patents at the Electronic Frontier Foundation. She worked in private practice as a patent litigator at Sullivan and Cromwell and Dury Tangri. After graduating from Stanford Law School, she served as a judicial clerk to the Honorable Timothy B. Dyke of the U.S. Court of Appeals for the Federal Circuit. In 2019, she spoke at the National Academy of Sciences and testified before the Senate Judiciary Committee on the state of patent eligibility law in the U.S. Ryan Abbott, MD, JD, PhD, is professor of law and health sciences at the University of Surrey School of Law and adjunct assistant professor of medicine at the David Geffen School of Medicine at UCLA. He is the author of The Reasonable Robot, Artificial Intelligence and the Law, published in 2020 by Cambridge University Press. He's published widely on issues associated with life sciences and intellectual property in leading legal, medical, and scientific books and journals, and his research has been featured prominently in the popular press. He is a licensed physician and patent attorney in the United States and a solicitor advocate in England and Wales. So we're discussing this issue of patent law and AI inventors at a very opportune time. Around the world, there are a number of courts or regulatory agencies which are grappling with this very question of how to handle these new applications. The PTO just concluded a call for comments on the impact of patent eligibility on innovation in AI. And more broadly, there are, I think today's topic of conversation touches on a number of fascinating questions around AI and legal personality, including whether other forms of IP protection, such as copyright, should be given to non-human authors. So there are a lot of fascinating debates taking place in this space. Today, we're only going to be focusing on patent law, but I think that the discussion and the potential implications of these decisions have wider implications. I'll start, I think a good place to start is with the Dabus case, which is probably going to be of significant relevance in fleshing out this issue. I assume that many people in the audience may not be familiar with it, but the short version is that Dabus is an AI implementation which was developed by Stephen Taylor. According to Taylor, that AI system, Dabus, then created several inventions autonomously. Taylor then filed patent applications in the US, the UK, and in the European Patent Office, naming Dabus, that system, as the inventor. So why don't we hand it over to Ryan first to discuss that case a little bit and tell us about what those offices decided.
Sure, and it's a real pleasure to be here speaking with everyone. So essentially, in these two inventions, we had an AI system that was designed by a person, but not to solve any particular sort of problem. And the AI system, rather than a person, identified the novelty and value of its output before a person did. And on that basis, there is not a person under US or UK law, although it does vary by jurisdiction, who qualifies as an inventor, which is why the machine is listed as the inventor. Of course, no one has argued at any point that a machine should be owning patents. The patents would be owned by the owner of the machine. under common law principles of property ownership, like accession and first possession. But we filed these applications now in 17 jurisdictions. In July, for the first time, a patent was granted in South Africa to Dr. Thaler with the AI Davis named as the inventor. In 3 days later, the federal court in Australia issued a 41-page reasoned decision holding that AI was appropriately named as an inventor and that the AI's owner was the prospective owner of any patents generated by that AI. And that decision is being appealed. The US, the UK, and the European Patent Office have all denied the applications on the basis that they don't name a natural person as an inventor. And because of that an AI-generated invention is unpatentable. All of those decisions are under appeal. We recently, last week, had the Eastern District of Virginia reject our motion for summary judgment, attempting to overturn the US Patent Office's denial of the applications. That's being appealed to the Federal Circuit, and the case is currently before the Court of Appeal in the UK. We're expecting a decision in October, and there's a legal board of appeal hearing at the European Patent Office scheduled for December.
Great. So that's a fantastic introduction, especially given the broader global context and the way that different courts are going to be engaging on these issues, which we'll address in a second. But keeping it in the U.S. context for now, in denying Thaler's attempt to name Davis as the inventor, the USPTO noted that the U.S. statute states that what is patentable starts with the phrase, whoever invents or discovers a new and useful process. The PTO said that suggests that an inventor must be a natural person, and that was the congressional intent. Why don't we go over to Alex? Do you agree with the PTO's decision and that the statute requires inventors to be natural persons?
I do agree. I think I would take it even one step farther than where the PTO went. So they looked at the statute and the word whoever, but where I think the principle actually comes from is the Constitution. And the Intellectual Property Clause gives Congress the right to grant to authors and inventors certain exclusive rights for limited periods of time. And so you mentioned we're talking about patent, but this issue comes up in copyright. And I would say even if you go to the Constitution, that actually they're intertwined there, because this notion of exclusive rights is to authors and to inventors, and that there actually is embedded in that a presumption of human ingenuity. And I think that makes sense if you look at what the goal is, right? The goal is to incentivize people to create things. And people have options, right? People, you could spend your time going on vacation, you could spend your time procrastinating. And the idea is to provide an impetus to say, well, actually, of all the things I could be spending my time with, I'm going to spend it on creating stuff. And so there are a number of reasons why I think it doesn't make sense to broaden the definition of inventor or author to include, I'll say, animals and machines. You know, I think given that we're in 2021, we might have a different conversation about like aliens and alien inventors, but that hasn't come up yet. But I think that the concept is that there's some kind of consciousness that is the source of the creation, some consciousness that's capable of making choices about what it's going to do and capable of choosing to invent or not invent. And so I think the PTO could have gone one step further, but that they absolutely were right in reading the Patent Act to require a human inventor. And I do think like this has come up, if anyone remembers, maybe like the monkey selfie case was the copyright equivalent. And I actually think it's, and the monkey took a fantastic selfie, but was denied a copyright. And I think the same principles would apply. And also that if the rules were going to be changing in the patent space, we'd actually really have to rethink the status quo in the copyright space, because the notion of authors and inventors are put in such clear parallel by the Constitution.
Well, perhaps just to respond to some of that, I mean, on a few points, First on the copyright front, I agree. A lot of these issues are very similar. Naruto, the monkey, never got a copyright for that photograph. It is a different case in a lot of ways, but also ultimately that case was just rejected on standing by the Ninth Circuit, which decided that animals don't have the right to sue for things. So we never really got at the Copyright Office's human authorship requirement, which I too think is deeply mistaken, and also not harmonized internationally. The United Kingdom, for example, explicitly provides for protection of AI-generated copyrightable work and just legally fictionalizes the producer of the work to be the author. But I think this does get at the policy issues Alex raised, which is why we have a patent system. And it is to incentivize people to do sorts of things, but not necessarily directly to invent. Because especially in the patent context, most patents are owned by companies. And it is much more of an economic incentive to get companies like Pfizer to invest in making things like new COVID-19 vaccines. And with improvements in artificial intelligence, we are moving from a paradigm in which we have to encourage someone to sit in a lab rather than procrastinate, to encourage companies like Novartis to make very sophisticated artificial intelligence systems that are going to make new drugs. That's a tremendously expensive and complex undertaking. And right now, the patent office is saying I should stop moving around with pharmaceutical companies, but we'll go GSK, is saying to GSK, even if you can, work with a company that has an AI that makes a better COVID-19 vaccine, if you need a patent, we're not going to encourage you to do that sort of thing. You are going to have to use people for that, even if it's less productive. And if what we want out of the patent system is mainly more socially beneficial innovation, which is what we want, we should be encouraging companies to make, use, and develop inventive AI. And on the constitutional front, well, again, it gets to the policy arguments. But for example, corporations can be authors in the United States under the work for hire doctrine. So it is much more in this context that we need an economic incentive for a company than we do to get someone to stop binge watching Witcher on Netflix.
I'll jump in and to say, I think that it's true that the way that copyright and patent work is actually that they are not, you think of who artists and inventors are, right? Or, a lot of scientists, that actually a lot of these people have, an impulse to create. And I think, in fact, that perhaps the limitations of these doctrines are maybe in not reflecting what the actual creators need. But I think it's a really big change to say the purpose and the constitutional purpose is actually to incentivize companies to invest. A lot of patent law is about the small inventor, the guy in the garage. And I do think right at the end of the day, we are talking about people or potentially machines doing this. And one route is to say we need Pfizer to invest. But the truth is, NIH actually is an owner of one of the patents on the Moderna vaccine. And in fact, we are also incentivizing humans to make choices about what careers they pursue. And the role of the IP clause is to incentivize new invention, but it's also for the progress of science and the useful arts. It's supposed to incentivize economic growth, right? IP is actually a part of innovation policy, is a part of economic policy. So if one of the concerns as a policy friend I have is that if you end up incentivizing companies to invest in AI inventors, we're effectively incentivizing them to de-invest in people. And already the problem of automation is one that's creating a lot of economic concern and probably feeding economic inequality. And I actually think by ensuring that the IP clause is working to channel incentives to real people is one of the ways that we can ensure it's something that does produces good results for everyone and produces more innovation, but not at the expense of people.
Well, Michael, I'm just smiling because you only had to ask that one question. I think Alex and I could just take 45 minutes here, but that's something else I disagree with. That essentially turns IP law, although this is an argument I hear often from continental Europe, into a protectionist measure for people. And that isn't an efficient sort of protectionist measure. And I don't think if you step back and think about it, it's something we really want, especially in the patent space. So you might imagine that, in 10 or 20 years, Dabis or DeepMind or whomever, gets much better at making inventive machines to the point where they are automating a substantial amount of innovation and displacing human inventors. But even if that happened, it would mean that we had machines that, for example, in drug discovery, were just constantly churning out useful new treatments for things. And that would be something that would be tremendously socially valuable. And if that puts a few scientists out of work because machines are now doing a better job at inventing than they are, well, first, for a long time, there's going to be other sorts of things they can do. But secondly, it would mean that patent law is now just keeping someone inefficiently doing something, that they really shouldn't be doing in the first place. I think as a social matter, we're going to see that with copyright much sooner. I know we said we weren't going to talk about copyright, but here we are, and Alex does copyright too, I think. If you have a machine that could make great music better than Katy Perry, and you were driving around listening to AI generated music, that too would put some human musicians potentially out of work. But again, what is it we're trying to get out of an IP system? And I think that the main thing that we're trying to get is socially valuable output, whether that's designs or movies or innovation, and that people will find other useful things to do. And if we ever get to a point where there are so many things a machine can do, a person really can't do anything, well, first, that's going to happen regardless of an IP system or not. And secondly, that would be a world in which we had unlimited wealth and the cure for all disease, and we would just get to be in virtual reality all day inventing things.
So I do want to jump in briefly because this is fascinating, but I want to corral the conversation slightly and dive into those last points that you were making in terms of the practical public policy impacts. The purpose of arguments are interesting and certainly very relevant to judicial considerations and regulatory considerations. But if we imagine a world where AIs can be listed as the inventors on patents, what are the concrete and tangible benefits, Ryan, first, that you would see flowing from that?
Right. Well, I mean, the primary problem here is a commercial problem, which is that, in the United States, it is not only something that can render a patent invalid and unenforceable, but a criminal offense to inaccurately mislist yourself as an inventor. And in this case, there is no person who traditionally met inventorship requirements. And while some jurisdictions may allow not naming an inventor, like Israel, in the US, a patent has to have an inventor or you can't get a patent. So if no one qualified as an inventor, and if a machine could not be listed as an inventor, even though it factually invented something, as the patent office said in the district court hearing, then you can't get a patent for things made by Davis, right? And if you can't get a patent for autonomous AI output, then it is discouraging people from using machines like that in ways that are going to generate socially valuable innovation. And that's a problem today. But given the pace at which machines are doing this sort of thing and improving at doing it, it's going to be much more a problem in 10 years. So the real problem with not being able to list a machine inventor, unless you change the law to allow it some other way, is that you would be creating a whole new category of things that couldn't get patent protection.
And Alex, so I don't know if you want to either directly respond to that or discuss what you see as the public policy shortfalls or challenges that would result from that kind of recognition.
Well, I'll do both. I want to address that last point, the notion that would be creating a whole new category of things that aren't patentable. And I guess I actually think a lot of the stuff that isn't patentable because it's not a human inventor is actually also not patentable when it is a human inventor. There's been a long debate in the pharma space about whether sweat work, whether really in-depth data analysis should be something, people work really hard, they did all this data crunching, but actually, right, it's not an invention that's patentable just because it's actually new and useful. It's got to be non-obvious over what came before. And actually, as a result, it's not an invention just because somebody made something new. There are additional requirements, and just kind of crunching data is actually, I've worked on cases where, I think you could argue, I actually worked for somebody who lost a patent. It was a patent owner on a pharmaceutical for improving walking speed in patients with MS. And it was actually, they had done a ton of studies. None of them produced statistically significant results. And the named inventor realized that like actually if you looked at the data, there was a way to find a statistically relevant result, but it involved figuring out that the relevant metric was walking pace, that the relevant dosage was to not increase up. It was 10 milligrams a day and to not change it. And actually, like, I think that was actually pretty clever. But it was ruled obvious by a Delaware district court and upheld by the federal circuit. And it was even not a terribly close case because all of the data existed. It was all there. And it wasn't actually, and I think that is where it's important to not think of, we talk about factually inventing, but that inventing, I think in the eyes of the founders, that there is actually something uniquely attributable to consciousness, that it's about going beyond what is here. And I even, we think that these folks were kind of, came from a deistic tradition. I even think, that there is something about the way that a author maybe would get, inspiration from somewhere higher, that inventors do. There's some transcendence. And so that's why I think really like the very concept of invention is something bigger than just making stuff or that's new, right? Because bakers do that every day. And so then on the negative side, I think it's really important that, part of the idea of the patent system is to create new stuff, but also to ensure public access to stuff. And if you imagine in the 1700s, if somebody invented something and it didn't, even if they marketed it in their town and they died, it's very possible that nobody would ever know that happened. And so it was really important to incentivize them to tell the patent office about it and create this storehouse of knowledge that would have perpetuity beyond them. And there was a public benefit of that, of ensuring that the public would be able to benefit from these really inspirational, ingenious things that people came up with. And so I think it's important not to parse the public benefits from the purpose of this, and the fact that we already, right, the sort of sweat work of researchers is not patentable when they do it. And so I think making it patentable when a machine does it is really, really quite dangerous. And already, there's, problems, given, I think the notion of IP might be protective of people, but I would argue like all law and government is designed to be protective of people. And so, to me, that's a pretty core need that IP law has to meet, is that the goal of the beneficiaries are people, citizens, not corporations.
Well, just to respond to some of that, I'm not sure we disagree on all of it so much. I mean, firstly, certainly the purpose of naming an AI as an inventor is not to benefit a machine. It is to benefit people. It's to benefit people by encouraging people to develop machines that invent things, to be factually accurate about what invented something, so I can't take credit for 10,000 things DeepMind invented. That is certainly the case. I'm trying to remember the earlier thing that you said about that. Alex was pointing out some problems with patents generally, all of which may well be true, both on the access front and on the stupid patents front, having had the best job title ever in history previously. But that's really very different than what we're talking about here. I mean, if you're saying there are things that shouldn't get patents because they're obvious, the law already doesn't let you get a patent on an obvious sort of thing, notwithstanding some challenges about figuring out what's obvious. This is saying, well, assuming you have two non-obvious inventions, which we do in this case, as already determined by the UK and EPO, the fact that a machine made it really shouldn't have any bearing on whether it is a socially valuable sort of thing that we want to protect. And, that is the case in these two inventions and will be in the future much more, I suspect. And then I just kind of forgot what I was talking about. It'll come to me, but maybe we should move on so we're not all waiting on me.
Sure. I'll maybe push back against the points that either of you are making slightly, if I can. Maybe starting with Alex now. Ryan was just talking, or actually, I think in your last intervention, you mentioned this idea of you wanted to create an incentive structure for people to share knowledge, so that if somebody in a little village in Italy creates some great invention, and that the secret doesn't die with that person as it might in like the 15th century or whatever. If you don't create a system where these inventions are patentable, is there that risk that you will stop having that same incentivization for people to share their inventions, that these inventions will then be kept secret as they're generated?
Well, I think it's important to distinguish like the keeping the invention secret and the public getting the benefit of what that invention does. Because I think in this situation, right, we're assuming that the reason that these inventions produce things, they come up with drugs, they come up with this, they come up with something that's going to go on the market, right? And that's enough for there to be a benefit, right? And I think that, you know, where patents have the potential biggest role to play is if, you know, the cost of innovation is really high, then putting it on the market creates a risk of people copying it, that they would never be able to recoup their invention. And the truth is, in a lot of software fields, you know, the cost of invention, the cost of innovation and of distribution is relatively low. And so the role that patent plays in protecting that incentive, and I agree that this is different in pharmaceutical industries, but I think that that's different. And then on the second point about the potential for secrecy, I think frankly, this is, I think a major problem, particularly in the software space, is that the requirements of disclosure for how your invention works have gotten so lax that, especially in software, it's enough to say that, well, a reasonably skilled programmer would understand how to implement this. So copyright, you get protection for the actual code that's been written, sort of a thick protection. But in patents, you get, it's much thinner in terms of what has to be disclosed. And it's enough to say a person of ordinary skill in the art with this equipment would be able to write a program. And so as a result, there's very little information that gets disclosed in a patent about how something works. And so I think actually a real concern that exists is that you have patents and it's still not enough to know how they work. And I mean, an example is that though we have there's various patents that relate on the various, COVID vaccines, but they actually don't disclose how you make them, right? That's one of the arguments that's come up in the TRIPS context is companies saying, well, I mean, who cares if you make the patents available, because that's actually not enough to help manufacturers produce these biologics. So I think that in fact, I'm not concerned about that, because the way our patent law is right now, the disclosure requirements really, unfortunately, don't provide enough information to make the knowledge about how to make it available to the public. And in terms of the benefits of the use, that I think in the software space, there's plenty of economic incentives. And that's sort of the premise of the situation, is that these are products that there's going to be a market for.
Michael, just to follow up on that, and thank you, that was the third point I wanted to make, was the trade secret point, which is, if you can't get a patent for this sort of thing, then your really only option is to protect it by trade secret and never let the public have the benefit of disclosing how the invention is made and used. Now, there is a requirement that to get a patent, you have to, comply with written description and enablement requirements. And if you are not disclosing something so that a skilled person could make and use it, you should not be getting a patent on it. The argument that sometimes that may be applied in too lax a manner, along with most of these arguments, are just sort of anti-patent arguments generally, not really anti-AI generated patent arguments, though I take them in. The software industry works different than the life sciences industry, although as it is, we have one patent system that applies to all of them, though, under various sorts of case laws, there is some differentiation, but also in the pharmaceutical context, and COVID, is of course a big issue in and of itself, and the patent system engaging with that. But in life sciences, the cost of innovation is generally not the most expensive part of this process. Estimates differ on this, but the pharmaceutical industry claims that it costs on average about $2.4 billion to get a drug approved, and it takes 8 to 10 years. And that only works if someone is going to have a means of recouping that sort of investment. The primary way in which that is done is through the patent system and market exclusivity. So, again, without patents, you are, where you have a patentable invention, not permitting these sorts of inventions to come to market and for the public to get the benefit of them.
So I do want to pick up on exactly that last point in terms of the the breadth of the patent system and the way that it may be a better fit for certain areas of innovation than for others. Or I guess I should say the lack of specificity that's applied to different levels of innovation that maybe require different levels of exertion or investment in order to bring to market. So, if we are talking about the cost of innovation here, presumably, if the cost of innovation of these things is going to be comparatively lower in certain instances. So does that potentially speak? I wonder if either or both of you would agree with an argument in favor of a broader recalibration of how we apply patent law to different kinds of invention, and a broader need to think more critically about how it applies to different types of innovations, and what that would potentially mean if we were to develop a more category-specific type of patent law for these kinds of inventions. Would you, I guess, Ryan first?
Let's
start with Alex. She's already got an answer to this.
I mean, actually, I would say in some ways the opposite. I would first start with would be applying the laws we have with equal rigor to all areas. And the truth is that I'm actually quite pro patent law. What I think is unfortunate is that I don't think it's applied rigorously enough. And part of the problem, frankly, is that patent examiners just don't have enough time. There's a Professor Melissa Wasserman and Professor Frakes have done a number of studies over the years that show, examiners get about like 18 to 19 hours over a couple of years to review an application. And somewhat counterintuitively, the more experience an examiner gets, the less time they're allowed to have in reviewing. And perhaps unsurprisingly, data is very clear that if you give examiners more time, they will grant fewer patents. And if you give them less time, they will grant more, because the default is actually allowance. If an examiner can't find a ground of rejection, the application has to be allowed. And so, in fact, these professors also did like a cost benefit analysis as applied to certain kinds of pharmaceutical patents to show that it's like extremely worthwhile to double examiner times in terms of the cost that the lost generic competition imposes on the government through like Medicare programs. So I actually think that if we gave examiners the tools to do their jobs the way they want to. I mean, I have frankly spoken to examiners who are incredibly frustrated and under pressure to allow patents they don't think should grant. And there's studies, there's reports, the government has done surveys where examiners, themselves completely admit they don't have enough time, that one of the biggest obstacles they have are time limitations in doing thorough reviews. So I very much wonder and would love to see what the patent system would look like if examiners had enough time. And I think also there's some real peculiarities about the qualifications to be an examiner. So in order to become an examiner, you have to take the patent bar. In order to take the patent bar, you either have to have certain degrees or done certain kinds of coursework. And even though the patent office grants computer science applications, if you have a degree in computer science, that is not generally a qualifying degree. And so I think that is a real problem, and that examiners, we need to be hiring examiners with the qualifications that match the applications. And we need to be giving examiners enough time to do their work. And I think if we did that, I think we might really, I sort of push back on the notion of being anti-patent. I think it's like if you have a party and there are some guests who are breaking the rules and throwing things and throwing their drinks around, and you ask them to leave, like, you're pro-party, you want a better party. And so that's where I come down on this, is I think we could actually have, higher quality patents of all kinds if we started with empowering the patent office to apply the law and empower examiners to review applications. And I mean, review more prior art. One professor, Lemley, did a study that shows examiners basically ignore the prior art that applicants submit. And they end up citing the same references over and over. It's like they develop a little menu, and presumably as a time-saving device. But as a result, and I think who this really hurts actually is the small inventor, because right now, if you have a patent the odds of it, of an invalidity challenge succeeding are so high that a big company is gonna say, sue us. We're not gonna pay for a license. And if you had incredibly high quality patents coming out that you knew were really well reviewed, then that small inventor maybe is a much bigger shot of having a license or at least a negotiation. And I think we're all better off if, instead of money going to patent lawyers, they were going to engineers.
Well, I do take issue with the idea that less money should go to patent lawyers. But beyond that, it strikes me this has moved a little far afield from AI inventors, but as general critiques of the patent system, I agree there's nothing wrong with enforcing the rules we have on it, and that if a patent isn't adequately described and isn't non-obvious, it shouldn't be granted, and that there are ways in which patent examiners could probably be more efficient, and granting them more time and letting computer scientists in is probably a good idea too. That that would benefit everyone, because we shouldn't be granting patents that should have been granted in the first place. It causes a lot of cost down the road, really, for everyone. But all of which isn't to say that the patent system isn't one of the primary means by which we encourage socially valuable innovation in this country, and that when we are encouraging people to have machines that build very useful sorts of things, that isn't the sort of thing that should be protected just as well, because the same sort of incentives and economic incentives have to apply to it. The idea that only a person can conceive of a new invention, leaving aside animals and aliens, which are interesting sorts of ideas, to me really isn't that relevant. I mean, both as a legal matter, because once something's in an application, it's been conceived of. But as a philosophical matter, Congress used to have, or we used to have a standard called the flash of genius test, where examiners and courts would not just look at whether what someone outputted was objectively non-obvious, but whether it came to them essentially in a flash of genius. Not only did this result in courts knocking out pretty much any patent they touched, but also it was just a terribly subjective and meaningless standard that judges were trying to read into what someone was thinking when they came up with something. And whether we're getting inventions out of, the guy in the garage, a room full of monkeys, or a machine, what we as a society really want are things that are socially valuable, like new drugs and new cool electronic things. And, that is the sort of thing that we are promoting under this system if we do protect these sorts of inventions.
So sorry, go on.
One thing I want to just throw out there, which maybe actually I'd be curious if you have an answer, is that if the goal is to be also is incentivizing the people to invest more in AI, it does seem to me that there isn't a clear reason why a human inventing a form of AI, or even inventing a product by process. Here's a drug that is created through X process, or a method of creating new bicycles, where in step 1 is program an AI machine, and step 2 is use it, and 3 is new bicycle. So I'm not actually sure that I'm clear that there is no possibility for giving patents to the human inventors for their work that incorporates their work with building the AI. And I may not be aware of something, but I would be curious if that's something that happens, if that's available, if there's any reason why that's not possible.
Yeah, most of the time, definitely possible. So there's a few different ways you can qualify as an inventor. Product by process is a little complicated, but I can get to that. One is sometimes finding a problem to solve can make you an inventor. Usually, though, it doesn't. Usually, we know what the problem is. So, for example, you're at Pfizer and I want a new COVID-19 vaccine, and I tell my 400 pharmacologists, make me a new vaccine, and they do. That generally won't make the executive an inventor, but it can sometimes. 2 is, yes, people have used AI and R&D for a long time, and if you use it the right sort of way, that probably makes you an inventor. Say you're that pharmacologist and you build a computer simulation to make that vaccine, and you train the AI very carefully and you build it for that purpose. That can make you an inventor too. But some of these AIs now being used in R&D are programmed by dozens or hundreds of people spread over time and space. And sometimes the people using the AI between your step 1 and step 2 make the AI and use the AI are different people. And if the people using the AI use it for something that the first group of people don't even know it's being used for. So say you make an AI that can design a better industrial component or a microchip design or a new sort of drug compound, but you don't actually know what's coming out of it. You couldn't qualify as an inventor under US patent law because you wouldn't have conceived personally of the claims, right? So you might know you've built an AI that can make a certain sort of thing, but not what it actually made, and that wouldn't make you an inventor. You know, the third general way one can be an inventor is by recognizing the value of a discovery. So if you are the first person to note that penicillin inhibits bacterial growth, and if an AI says, here's 10 possible vaccine candidates, go test them and find the one that works, that would probably make someone an inventor. If someone just says, I'd like a new COVID-19 vaccine, and the AI says, here's the vaccine, I'm 99.9% confident it's the best vaccine you could come up with, here's the clinical testing you do, and here it is pre-formatted as a patent application. Not that we have an AI that does all those things yet, but we have AI that can individually do many of those things. There would be no inventive skill required as a person to be an inventor. Whether with no inventive skill, someone just reading obviously valuable output from an AI and qualifying as an inventor that way, is something that hasn't been completely determined yet and is also jurisdiction dependent, but is probably not enough to qualify someone to be an inventor. Product by process also, one has to understand, what the ultimate product will be and have a reasonable expectation of success with it. And so building a machine that invents in certain areas without knowing what it's inventing probably wouldn't do it for you either.
It sounds like potentially that you could just, what you described, the one where you've got a lot of people working on something. There's a lot of innovation that starts with, like groups of scientists where some, I have friends who 10 years later, they're named on a patent application. They didn't do work on that, but it built on work they did. It sounds to me like it's just an administrative difficulty that people don't want to list a lot of people on the invention, but you could, in theory, do that and just have really a ton of people, a ton of named inventors.
Well, you could have a ton of claimed inventors. And to be clear, inventorship as an area of patent law is a messy area. And these things are rarely, though they are often an issue in patent litigation, there's not a whole lot of US case law on it or case law in other sorts of areas. And some of it is squishy, what makes someone an inventor versus in US parlance, what makes someone helping you reduce something to practice. So yes, it might be the case that the group that builds the AI, all of them are named as inventors, but again, that doesn't work in a case where one of two things happens. Companies like Helix or Benevolent AI or Atomwise are building AIs that they are licensing to pharma companies, and the people building the machines aren't the ones using it and don't know what they're outputting, right? So then they have no real connection to the claims that are coming out. And B, right, if someone isn't inventing something to do something very specific, like parametric optimization of a new car suspension, Dabas, for example, was not built to invent a flashing light or a beverage container. That's just what it came up with. So there would, again, even though someone built the machine and the machine is itself patented, that is different than protecting its output, which in the US is currently unprotectable.
So you mentioned in the US specifically, I want to ask a little bit about whether either of you see the differing standards here from jurisdiction to jurisdiction as potentially be problematic. US patents being asserted in the US, but not in Japan, Japanese patents asserted in Japan, but not in the US. If different countries' approaches on this particular issue start to diverge, and if AI patents become increasingly important, are there potential, is this an area of concern? For example, would it complicate things in relation to international applications filed under the Patent Cooperation Treaty? Is this itself a public policy concern, or is this just another area where different jurisdictional laws might differ?
We already do have different, rules and standards, and there are, UK patents that come in through the PCT, which gives them a priority date, but they're still reviewed under US law. And I saw one recently where it is then amended, further in connection with US law. So it's already, a patent that's in the US is only effective in the US, only on US soil. A patent granted in Japan is only effective in Japan. only on Japanese soil. So there's no like overlap that's possible. And in fact, I think the situations that are really problematic, in fact, is when you have something you have a patent family that's been granted in a ton of countries. I think that's actually when you have, in some ways, the most complicated scenario, because then you have litigation going on in 30 countries, and frankly, forum shopping. Some countries in Europe have great injunction standards. Others have really great damages. Or maybe you've got a litigation in the US, and so you're going to call the customs patrol in Spain and have them block a shipment of products to the customer of the person you're suing. I've worked in cases where that happens. And then they come back to the settlement table. So I actually think that even if you had one patent, it's granted then, and there's a patent match in every country, that creates a whole lot of complications. So I don't think that uniformity of protection is a bulwark against international complexity and confusion in terms of consumers and sales and markets.
Well, to give the opposite opinion on that one, as a procedural matter, not terribly difficult. So the Patent Cooperation Treaty accepted our application. It lists Abbott as the inventor and Dr. Thaler as the patent applicant. But that is really mainly a procedural process by which it then gets triaged to different jurisdictions. And yes, every jurisdiction has its own rules on this and its own local purview for patent infringement and validity and so forth. And so, getting a patent in the US isn't quite the same as getting a patent in Japan. That being said, the patent system is really very highly harmonized for exactly this problem. And Alex mentioned TRIPS, and I'm not sure if the entire audience is familiar with TRIPS, but essentially it is a international treaty that requires all member states of the World Trade Organization to provide minimum patent protections for just about the same sorts of things. And there are some differences in application, some things that are protected and some things that aren't. But as a general matter, whereas before TRIPS, you had different jurisdictions with wildly divergent rules on this, any product or process generally has to be protected in all of these places. And yes, at present, what you're going to have is a few jurisdictions. Well, who knows how it will ultimately play all the way out. But I think it's fair to assume that some jurisdictions, as it is now, will protect AI-generated inventions and some won't. And that means that if you have an AI company in the United States, that you're spending a lot of money to make socially valuable innovations with, you only get protections for that in some places and not others. And essentially, it has a negative impact on innovators because they aren't able to recoup the cost of their investment and their commercialization of inventions. And some countries are paying for that and some aren't. And this is fundamentally why we have a harmonized intellectual property system and why WIPO, the World Intellectual Property Organization with a terrible acronym, has been having a series of stakeholder meetings so that different jurisdictions can think through this and, potentially consider a harmonized international treaty on this, although that moves very, very slowly. But it is a real problem for people using AI in this way, that they'll only get protection in some places and not others.
So I have one more sort of question for both of you. And then I want to open it up to the Q&A because we've got some wonderful questions coming into the chat. In patent litigation, sometimes it's necessary in a case for the inventor to be deposed. How would that work if the interpretation of the law were changed to recognize AI systems as inventors? I guess Alex, do you want to start, or?
Well, I was just to add on that, inventors have to be deposed. They also have to swear like a duty of candor. And that everything that they say is true to the patent office. So there are a number of places where we expect inventors to make declarations of truth. And it is interesting in the deponent context because you often do need to get testimony if there's a priority contest or you want to find out evidence on obviousness, or if sometimes it comes up because you want to find out if they actually did prior work that maps onto the invention beforehand and didn't patent it, and so created their own prior art to their work, or if they made commercial rather than experimental uses. And under U.S. law, under hearsay, a machine is not a declarant. And so I do really wonder how you could have a machine take an oath and swear to tell the truth, and how you could have a legal system without that possibility. Not to mention that it is actually also part of the patent application process. So a lot of patent litigators would be much happier if you took that out of the equation. But the Supreme Court actually in the Minerva case recently confirmed and sort of partly holding up this doctrine called the signer estoppel, but held that inventors actually kind of make an implicit assurance to the patent office that they believe their patent is valid. And so there are these various places where what the inventor believes and the ability to inquire after what they believe are important and important parts of patent litigation that would seemingly be inconsistent with how US law treats machine declarants generally.
And I tend to think that the answer to this question, which isn't just in patent law, but is in all sorts of areas, as you talk generally about the center's interest in accountability and like having self-driving cars that run people over, is yes, we'll be deposing machines. It'll just look a whole lot different. We will be deposing the people involved with the machines, and we will be having forensic analysts looking at the machines and explaining why certain decisions were made and the inputs that went into the machine. And yes, you're certainly not going to get a machine, well, A, in a traditional deposition, or B, making an oath that they think things are accurate. But on the plus side, I tend to think that machines are a whole lot less likely to lie than human inventors, because human inventors have all sorts of incentives to lie in litigation, and machines, I think, ultimately may prove to be more transparent than people, in the sense that, the answer to these questions, what was the machine doing? Why was it doing it that way? What input did it have? Are things that with resources and interest, one can get definitive answers to. And so I think that these are all, problems that are analogous to ways in which human inventors do different things, but will have to be somewhat restructured.
I would add that similar problems about maybe the limitations of forensic analysis come up when AI tools are used in criminal cases, and this is actually a real problem because there are a number of situations where very detailed analysis is used to put somebody at the scene, and it's really hard to do a cross-examination of that data. There's a huge amount of code that goes into writing them. And so how do you actually assess it to know that the machine wasn't programmed to perhaps, provide the answer that saves its own invention? And it's actually, as a practical matter, it may sound simple, but I think it's actually quite difficult. And the truth is that it's probably very likely that still these companies will want to keep the code non-public, which means there'll be a lack of public access where you have the public able to, in most cases, read a transcript and understand it of an inventor. But you probably will have people with where the public won't actually have access to the code and be able to see it. So we'll be relying on forensic experts who are paid by the parties, and I don't think you'll ever have the same assurances of truth and just the ability to evaluate credibility that the legal system relies on outside of patent law as well.
So, but, just very briefly, it's a fair point, right? I think the gist is this, many of these challenges that exist with people doing things exist in analogous ways with machines doing them, right? Like when you have an expert witness at trial saying, I can tell from a video or whatever that there's someone at the scene, right? We have these same sorts of challenges around bias and transparency and explainability. And it is not always easy to tell what a machine is doing. Sometimes it is much harder than a person, but we shouldn't act like these are new sorts of challenges. And I think that in some ways they may be more insurmountable challenges with machines that, tend not to be programmed to deliberately lie and which are amenable to looking inside the box or even to looking at sort of objectively generated outputs in ways that you can't do with people who have all sorts of challenging motivations in these cases.
So this is fascinating, and I'm very glad that this is just right now touching on these broader implications of how all different areas of the law are having to figure out how to deal with these autonomous systems. We have some fantastic questions in the chat, so I want to start going through them now. The first one from, I think it's D. Le, I'm going to say those could be initials, but I'm going to take a stab at it. That touches on the wants to ask about the way in which patent filings can be used in anti-competitive ways in order to stifle innovation of others. I'm sure this is an area that Alex has worked on extensively. Do either or both of you have opinions on whether allowing AI inventions in the door there might exacerbate this challenge, or is that not an issue?
I think my concern is that so one of the ways that patents can be particularly used in anti-competitive ways is that a lot of times companies, they don't just have one patent, they have what we refer to as patent portfolios. So they might have thousands or tens of thousands of patents that read on a particular technology. So your product doesn't just infringe one patent, it infringes thousands, which means if you're a defendant and you think that the other patent is invalid, and there's one patent, you've got a shot at proving it invalid. But if there is 1,000, that is almost just an insurmountable, inconceivable amount of work. And so and the other, you've got some unhelpful, case law that allows, a portfolio, you can, especially in the context of patents that are essential to technical standards is where a lot of these portfolios are particularly prevalent. So your cell phone uses the 3G standard, 4G standard, and there are patents that have been declared essential to each of these standards. And there are companies with portfolios. Interdigital is a company that has many portfolios of standard essential patents that it levies in all kinds of anti-competitive ways and is the subject of an antitrust suit, at least right now. So to the extent that the problem grows as the number of patents grow, the fact that you could be having automating this process and theoretically we're generating so much more innovation, well, then we're generating so many more patent applications. And so I see the potential for the problem of these massive portfolios to grow on an order of magnitude. That would be one, a number of concerns, but I also think, that probably, it costs money to apply for and get patents. And if you're a brand new startup, I've talked to VCs who say, more VCs than you might think say, I advise my companies not to invest in patents until they're so big that they need them to defend themselves. That's the only value they have is for defensive purposes. This is in the software space. But, and so, really saying, especially when you're a small company, you don't have a ton of resources. So you're going to want to focus on your engineers and on your marketing and on all the things, the bread and butter to get your product out the door. And so the companies that have the most ability to just focus on patents and generating patents are the incumbents, are the ones that already have them. And so I do think that the combination of scale and giving an advantage to incumbents means that we would have increasingly that the sort of aside from the sort of direct effects in restricting competition that a patent has, that you'd actually be having more of increasing centralization and increasing barriers to entry to new companies.
I think that, those points are fairly taken, but are again, kind of general objections to patents rather than any objection in this particular space, and, two general thoughts on this. So one is, imagine you have machines that are better at doing what they're doing now in 20 years. So Google can essentially have an AI that can find the cure for any type of cancer. That would give them a tremendous monopoly position, and potentially 20 years of very high costs for paying for the cure for cancer, but it would also all at once give society the cure for cancer, which we would get after 20 years. And I tend to think on the whole that that's a beneficial sort of arrangement. And to the extent that we're concerned about people just generating large numbers of patents for non-practicing entities, that is, again, something the patent law already has tools to deal with, and where we are already working on, where the most efficient line is, from things like no longer issuing mandatory injunctions and just having reasonable royalties as damages, or to things like compulsory licenses if someone is generally, is genuinely acting, although we don't do that in the United States so much, in an anti-competitive sort of manner. So, these having patents does come with certain costs, and there are ways of dealing with these challenges under patent law as it is now. And again, I think the gist of this is, if what we want is socially valuable innovation, it shouldn't matter if it's coming from a machine or a person. And if machines end up doing much better at it, that means we're in a good place where we just have so much valuable innovation, we barely know what to do with ourselves.
Or we have so many patents on it, right? We don't necessarily sure we have it in the market.
Well, right. Patents are, of course, a type of property right that comes with certain costs, right? We use them to generate innovation and to promote commercialization and disclosure, and they give someone a time limited monopoly, with some potential ways of addressing that where it's used badly. But it will certainly, I ended that thought, but we encourage them to make it for us, to put it on the market, and their monopoly is limited.
So Daniel Shin in the chat asks about a recent case from the Eastern District of Virginia where the judge cited the U.S. Supreme Court statutory analysis of the term individual from the Torture Victims Prevention Act, which is not an IP law, in determining whether the inventor had to be a human being. Do either of you have a reaction to that?
Do you know? I'm curious if the person knows what judge it was in the Eastern District of Virginia.
Sorry.
Well, maybe because that's pretty in the weeds on the case. I'll answer it, and then if Alex has any thoughts, she can chime in. Two questions, right? I mean, so what was this bigger picture question with the case? So the Patent Act uses terms like individual. Does that mean that a inventor has to be a natural person, or how could you define individual? And there's two general approaches to that. One is, a narrow textualist interpretation, which is, well, probably individual more means a natural person than a machine. And one is a purposive interpretation, which is, well, what is the purpose of this statute and what are we trying to get at it? And what reading is most consistent with that? To the extent that there were human-centric terms used in the Patent Act, it was our position that this was just based on an assumption that an inventor would be a person, or at least not a corporation. But corporations and AIs are very different because corporations have to act through human agents and AI does not directly. In support of the textualist interpretation she, cited, which came from the U.S. Patent and Trademark Office, the Torture Victim Protection Act, and that case. Although even that case said, well, in this context, individual means natural person, but not just because of our dictionary definitions. Because of the statutory context, it was clear that Congress intended this to mean natural persons. And in a concurrence, Justice, I can't remember who even wrote, but that's not to say that an individual couldn't mean a corporation or other entities in a different context. So, we disagree with that particular analysis.
Okay.
I would just add that, I think one thing that the Supreme Court has been willing to do, though perhaps a little bit less recently, is it has been willing to require patent law to act like all other areas of law, which I generally think is a good thing. And so I will say that I didn't realize if the trademark case, I'm surprised. I assume the PTO didn't cite the torture Act, but I actually find it interesting. It looks like that judge presided over the Zacharias Moussaoui trial. I just think it's something interesting how, judges who hear these cases have their own, personal backgrounds that they're, bringing in sets of experiences. And that I think, right at the end of the day, the patent office grants the patents, but district court judges, are the ones who are in charge of deciding, or, presiding over the infringement trials. And I think it's like a good example of how valuable it is to have that input. And I think that we should expect, the principles of patent law and the way that we use words to be, equivalent to the way we use those words elsewhere. Patent law has a real tendency to get very jargony, and ordinary words have very, extraordinary meanings. So I appreciate the effort to harmonize the patent law's understanding of what an individual is with the word's understanding elsewhere in law. And I think that's an example where how are machines generally treated? Well, not as declarants. And I think that those principles are important.
So Fran Cabrera in the chat asks several questions, and I think they generally revolve around patent market inequalities or broader concerns about structural inequality. I'm not sure whether either of you see this debate as playing into those concerns, but I'm not sure. But I wanted to give you a chance to answer if you see this driving inequality in either direction.
To go, there actually has been increasing work on the ways that the patent system has had an effect on structural inequality in the U.S. There's and frankly, one example, or I think that I think that there's evidence that a person of color may have really been the inventor of the cotton gin and didn't get the patent, and the way that fed slavery in the U.S. And so I think that I think it's an important thing to be attuned to, and I do think the fact that we are thinking, the companies that are being mentioned in terms of the most likely, it sounds like folks to be getting these in terms of IBM or big pharmaceutical companies, right? That these are companies that are at the high end of structural the beneficiaries of structural inequality, shall we say. And to the extent that, they might be investing more in computers and less in humans, and that we're seeing that as a good thing. That is one of the reasons why I am concerned about encouraging companies to invest in computers and machines rather than in people, is because I see that as a way where, the patent system, I think, is supposed to do good things for everybody, and that it could aggravate existing structural inequality by providing additional incentives to not invest in humans.
Well, just to circle back on that, I mean, I do agree that the patent system is something that is primarily utilized by larger entities. Despite the comment about the guy in the garage, that is a romantic narrative of the patent system, but the overwhelming majority of patents are owned by companies. Mind you, the inventor of Dabbas and the person filing this is an individual, so I will throw that out there. But in general, this is one of the structural ways in which we in the United States promote innovation, and it has proved to be very efficient. And I don't think that's something we should let go of. Now, that is an aside from the fact that I think the primary beneficiaries of AI-generated value will be people who already have money in larger corporations. And I think that is something that we should give serious thought to redistributing. But I think that the way that tends to be done most efficiently is through more progressive tax systems. And we have been moving in the opposite direction of that. But I think that, reducing innovation for that purpose is not the right solution. Having a more progressive tax system is the way to share the wealth that we generate from this.
So Anil Bainder in the chat mentions a case of Dr. Koza, who I am not familiar with, but maybe one or both of you are. But they mentioned that they got a patent for an invention naming themselves as the inventor, then declared that actually the computer invented it. I think that the question in the chat is aiming at whether legal structures will lead to some sort of deception of the system, problems relating he cites problems relating from information asymmetry. I mean, I imagine that the incentive to not do that is that it would potentially invalidate your patent. But
it's actually we just filed an amicus brief in a Ninth Circuit case, a False Claims Act case, about where involving pharmaceutical companies that mischaracterize their own clinical test data. There is a duty of candor at the patent office, but patent examiners actually, they can't say anything about it except to say, we do not consider duty of disclosure issues. Like, there's a rule in the manual that says, like, that is all they can say. And in fact, to prove a patent invalid, there's a very narrow doctrine that allows people who are accused of infringement to defend themselves on the grounds that the patent owner committed inequitable conduct before the patent office. And in fact, errors actually the lying about inventorship is the lack of inventorship, or that they're not really the inventor, is another ground that can be used. Like, if you left somebody off who was really the inventor, that can be a ground for challenging the patent. So I imagine that there could be grounds, but I think it's fair to say, and totally not related to AI problem, is perhaps the lack of incentives for people to rigorously comply with the duty of candor. And that's not AI's fault.
Right. So Dr. Koza was one of the other, one of several people who a long time ago was saying that they had AI effectively inventing things. And he basically said that his patent attorney said, oh, just list yourself. No one will ask questions about this, and a machine can't invent something, right? And many people have reported that, which is one reason why we filed these cases, because there's a real lack, or there was a real lack of law and case law on this challenge. That is on the one hand a very simple solution, because I could put your name on these patents, Michael. They all would have issued in 17 jurisdictions and no one would have thought twice about it. But leaving aside the ethics of that, it is not a viable strategy for companies with a long-term view, because yes, when you do litigate the patents or they get challenged and you are getting deposed and you say, oh, well, the attorney said I could just list myself, but I actually didn't really do anything. It all just came out of a machine. And they said, well, we need a warm body, right? At that point, you have a problem with your patent. So it is an easy but a short-sighted solution, and one that I think is not right. It does encourage, as an easy way to circumvent this, just leave out what the machine did. And for some companies that don't really care what happens to their patent in 5 years, probably an easier one.
So we have a question from Hannah Chaco, who sort of implies that as AIs get better and better and better at this, and are able to do this at a faster scale, that the motivation for human inventors to be able to compete with AIs in doing these innovations will decrease. I'm not sure. I think that, judging by maybe what Ryan was saying earlier, maybe that's a good problem to have, that we have outsourced our innovation challenges to these machines. I'm not sure if you wanted to comment on that, or where you see. Maybe I could frame it as the broader social direction that we seem to be heading in, if a greater proportion of inventions are coming from these autonomous systems.
I mean, one thing to remember is that having a patent doesn't give you the right to make something. It gives you the right to stop other people from making it. And so I do think that in combining these, if we, and we're sort of admitting that it's really going to be corporations that own these patents, not the, we're not relying on AI to not relying on machines to sue, is you end up with a lot of corporate power telling people what they can't do. And that, that I think is a concern, though I will say that I happen to believe in the intrinsic desire of some humans to create and innovate. I think is hard to stop, and I think that you see that in fact, there are a lot of creators who work without obtaining patents. Open source technology is a huge area. All of our cell phones, all of our computers are incorporating a ton of open source technology, and there's increasingly like an open source biotech movement. So in Berkeley, there are some brilliant folks working on the Open Insulin Project, where they're trying to build open source insulin. And so I in fact believe that human motivation to create things of value for the universe exists independent of the patent system, and that no matter how many patents AIs get, humans would still be motivated to create things of value for the universe.
I'll say two things about that. One is it would be it is a futuristic scenario, right? But if it does happen in 20 or 30 years, it would be a great problem to have, that I couldn't compete with an AI in terms of inventing things, because AIs do such a fantastic and fast job of inventing things that people find of value, right? But as to your broader point about AIs putting us out of jobs, I think across the board that if an AI can do something better than a person, we want it doing that. If I go to see a surgeon and the surgeon says, well, you can have me do your operation or this Da Vinci robot, but the Da Vinci robot takes a third as long of a time. You have, fewer complications. It can get clean margins and a cancer removal in a way better than I can. Who would you like to do the surgery, me or the robot? I'd pick the robot. And if that means that physician can no longer practice as a surgeon, all that means is that having a protectionist measure would be, harming users and consumers to give someone, a job that they only need to be protected because they, can't do it as well as a machine could. if we ever really find ourselves out of jobs, Alex is right that people do work for remunerative reasons. I play chess, but a machine could beat, a machine on my smartphone will beat me for the rest of my life. And I don't just play chess, so that I, could be the best in the world. I do it because I find it intellectually engaging. People will invent things, play chess, make music, even if machines do things better than this, but we'll still capture all of that social innovation. And, if we ever again live in a future world where machines have generated an unlimited amount of value for us, I'm confident that people will find some other valuable way to spend their time, through self-enrichment or forming deeper human connections, or maybe just playing video games all day.
I just had this flash of our dystopian future of long bread lines of surgeons just desperate for work.
Well, if I can jump in, in the fact that the doctor is the one who's telling you the AI is doing it better, and your interaction is with the doctor who's telling you this, I actually think, right, who's really your care provider? It's still the doctor. It's still the doctor whose advice you're relying on. And I think that if somebody, at least for me, if somebody told me, do you want to get advice from a doctor or this robot who's really smart, and the robot is I think no matter what, I still want a person that I could talk to and who I can evaluate. Like I don't humans, for however many years we've got these imperfect tools, but of evaluating each other. And I think the fact is that kind of everywhere in the chain behind the AI, somewhere there's going to be a human. Somewhere there's going to be a human that's responsible for knowing when to use it, knowing what input to feed it, whether it's for, at least for a long time, for turning it on. And that, I think where the patent system should be focused is on where that human is in the chain.
Right. Well, no question, there's always going to be humans in the chain, right? There certainly was here too, just no one who served as an inventor. Your doctor point is interesting. Let's take a self-driving Uber. When you have an Uber you can summon to your house and you can pick between a person and a self-driving car, you might have a very hard time evaluating how the self-driving car is going to function versus, the driver who you size up, who you don't know that well. But we may have very good objective data that the self-driving Uber never or almost never causes an accident in 5 or 10 years. And I think it would be better to have a fleet of self-driving cars that essentially never cause accidents than a person who you could look at and get a sense of how good a driver they are in your first 10 seconds of interacting with them.
But so, I had somebody, there are a whole, Ryan Kalo, a professor in Washington now, was at the law school I went to, and he, I think our first week at a talk on self-driving cars, and we said, the thing is, there's a lot of accidents that, a self-driving car won't do that humans do. But there are some that it's going to be really hard. Like, for example, if you see a baby carriage and a shopping cart, right? No human is going to hit the baby carriage. They're going to know to hit the shopping cart. And it's actually going to be pretty hard to teach the AI. And I think as we're seeing, we're seeing problems with self-driving cars. And I also wonder if in the human chain, as the self-driving car comes to your house, if that's not why people are so interested in folks like Elon Musk, because actually there's still a person whose intelligence or ingenuity we're actually ascribing to the machine when it shows up there.
Well, right. I agree with that about self-driving cars in generally. And sure, these robots will make mistakes and harm people. They already have. But, the self-driving car doesn't have to be perfectly safe. It just has to be better than people. And that bar is shockingly low. 94% of human accidents are caused by human error. Human drivers through human error kill more than 1 million people a year. Medical error is one of the leading causes of death in the United States. And if a machine occasionally, makes a classification error that a person wouldn't do, it is still much more likely to cause the level of harm that people do. And we would be better off from a safety perspective relying on AI more.
I just I want to get us to one last question in the chat from Dila, who asks about this from a model builder perspective. In terms of patent viability, and they ask about whether it can be a multitude of models contributing to an outcome with minor or nuanced differences, or maybe training data differences. Does the invention get attributed to the general project effort or down to the model level in the instance where the specific data set and the outcome was made? I'm not sure if you followed all of that. I think that was to Ryan.
Yeah, and I'll give the lawyer's answer. It depends. I mean, these are very fact-specific inquiries. Who or what did what, when, and how? And is any of that something that qualifies you to be an inventor, right? So I don't think there's a one-size-fits-all model for this. And I think the companies are very active in this space, are having to design their R&D processes at the moment to have at least one person under an assignment obligation they can clearly point to who said that person's an inventor, right? So they don't have these challenges, but that's not a long-term efficient sort of way to structure this sort of thing.
All right, Alex, unless you wanted to have the last word. All right. Well, I enjoyed this enormously, and I think this was a fascinating discussion. I enormously appreciate both of you taking the time to join us. It was great to have two very different but both very richly informed perspectives on these questions. Our next event at the UCLA Institute for Technology, Law, and Policy will be on September 22nd, where we will be welcoming Alan Rosenstein and Eva Galperin of the EFF for a discussion on digital surveillance and ethics in tech. So the link to that is in the chat. I hope that some of you will be able to join us. Alex, Ryan, thank you so much. This has been fascinating and a great discussion to catch.
Thank you so much, Michael, and everyone for coming, ITLP. And I strongly encourage folks to go see Ava, a former colleague of mine who is awesome and always engaging and interesting things to say.
Great.
Everyone, it was wonderful. And Alex, maybe I'll see an amicus brief from you in the Federal Circuit.
I know, thank you for mentioning that. I thought that as well. Take care.
All right. Thanks, everybody. Have a great rest of your day.